Hi, everybody. Welcome. My name is Taylor Owen. I'm a CIGI Senior Fellow and a Professor of Public Policy at McGill University. And it's really my pleasure to moderate and host this conversation today. I think we're having this, as everyone watching is well aware, at a moment when countries around the world are reevaluating and in some cases building new competition policies to broadly, I think, do two things. To answer the question of does our current competition regime and competition authorities and competition laws need to adapt to the specific challenges of digital markets? And how, if so, how do these changes sit within a much broader digital governance agenda that is also underway and being built in countries around the world, specifically around digital data privacy reforms and online harms regulation? And I think we've seen, as we will hear from our panelists in a moment, that in the UK, the EU, and the US, this is all in active conversation at the moment. In the UK, the Competition and Markets Authority has created a dedicated digital markets unit and has begun to take action against recent large-scale tech acquisitions. In the EU, the European Parliament has just reached an agreement on the Digital Markets Act, which of course sits alongside the Digital Services Act and focuses on the largest digital platforms operating within the EU. And even in the US, we're starting to see major changes within the FTC. We're seeing lead advisors sitting in the White House on competition policy. And we're seeing a major bill on the Senate floor, hopefully on the Senate floor soon, depending on one's view on this, looking at competition and antitrust. And I think it's fair to say, in this sort of global shift that's happening in this space, Canada has been a bit late to this conversation. That being said, we've recently seen a series of amendments to the Competition Act that were proposed in the budget, and I believe passed just yesterday. And there's an anticipated consultation process over the summer and fall on our broader competition policy in this country. So I think now's a really good time in Canada for us to sort of pause a little bit and hear a bit from what's happened in other jurisdictions, how we might be able to, as we often do here, take advantage of this somewhat late to the game digital policy making process, take advantage of learning from what other jurisdictions have tried and are building. And we have a pretty amazing group here to help us navigate that. Chris Riley is a global internet policy and technology researcher, a former director of policy for Mozilla, and a former Internet Freedom Program manager at the US Department of State. He currently works as the principal of Cedar Road Consulting and as a senior fellow for internet governance at the R Street Institute. Stephen Kinsella was until recently an antitrust lawyer in the UK and US, working mostly in Brussels, and is now a specialist partner with the business advisory firm Flint Global in London, working across the UK and Brussels on this file. Orla Lynskey is an associate professor at the LSE Law School, where her research focuses on data protection and technology regulation, and she's currently visiting researcher at the University of Cambridge Law Faculty. So what we want to do to sort of kick this off, we're going to go through, each of our guests is going to make a few remarks about their perspective on how this competition agenda is evolving in various jurisdictions around the world. I then have a few questions for our group, and very quickly we will open it up to our audience here, because I know there are many in attendance with great authority on this topic, both in Canada and internationally. So with that, Chris, can I turn it to you first to talk a bit through what's going on in the US?
Absolutely. Thank you, Taylor. It's a pleasure to be here. Thanks to CIGI for putting this event together and giving me the opportunity to speak. I'll talk a little bit briefly, I promise, to talk history, a bit about politics, and a bit about the substance of sort of what's been going on over the past few years from the perspective of an advocate who, wearing a few different hats, I've witnessed a fair bit of this evolution. I think you called out a really important point, Taylor, in your opening remarks, which is that antitrust has sort of long been held to be sector general, not sector specific. And that tide has really changed worldwide, I would say, for better or for worse. I think it's absolutely valid to recognize that technology and the internet present these sufficiently distinct characteristics from the perspective of promoting competition. Sometimes I think it's good to think about antitrust and competition as not actually meaning the same things. And I think a lot of the substance as we get into these conversations can help us think a little bit in more modern framework how we could contextualize these. There really has been an incredible shift over the past 5 years. It's worldwide, as I said. My primary expertise is in the US, so I'll talk a little bit about the UK and EU in this, over the course of this panel, but my fellow panelists have much greater experience in that. I've seen three overlapping waves of change. The first is in media and the public awareness. January of 2017, there was an article in the New York Times by Farhad Manjoo where he dubbed the Frightful Five: Google, Apple, Facebook, Amazon, and Microsoft. Obviously, in Europe, they've been referring to the GAFAs for an even longer period of time. But to see that sort of New York Times headline article really cemented the techlash narrative that has been building up. And it translated into politics as well, with then presidential candidate Elizabeth Warren, with her spring 2019 break them up media post and big campaign narrative, which we've seen translate a lot into conversations in the past couple of years. The second wave, in parallel to that, has been litigation. So antitrust in the US and in many other places is a very broad general statute that gets developed through litigation and especially in the US over many, many decades of precedence. Actually, when I took antitrust in law school many years ago at this point, I walked away from that class convinced that in any interesting substantive case of American antitrust law, you could find precedents supporting arguments on both sides. The old saying about American antitrust is that old cases never really get overturned, they just sort of fall out of favor. So it's a complicated evolution over the past few decades. But recently, we've seen tons of antitrust laws being filed all around the world, including in places like Israel. But in the US, there have been major state cases brought by Texas and affiliated states, Colorado, Attorney General Phil Weiser, and some other states along with them. The Federal Trade Commission has obviously brought a very, very major antitrust case as well. Now, we've already seen some pushback by courts on the antitrust legal theories behind these, and the dance will continue. I'm personally not expecting to see these lawsuits lead to the kinds of major structural changes that the AT&T lawsuit produced in the United States. I do think maybe something along the lines of the Microsoft case where some level of structural change could come about through negotiation is possible. But in my opinion, that will take many, many years, and we'll be looking to the Digital Markets Act, the DMA in Europe, as its normative transformation of competition in the tech conversations before we will see these cases really channeling things. The third wave, I said there were three, is the legislative wave. So in 2019, we saw major academic reports that were sort of encouraged by, or in some cases commissioned by governments. The UK's Competition and Markets Authority did its final report on the search and advertising social markets. The European Commission's expert report came out. They commissioned 3 expert researchers to dig into tech competition issues specifically. And in the United States, we had the Chicago School of Business put out a major report. And all 3 of these reports have led to legislative developments. In the US, there was a 16-month investigation in the House of Representatives that released a large report in October 2020. And a few months after that, in the summer of last year, there were 6 bills introduced by the House Judiciary Committee with strong bipartisan votes of support. Now, these 6 bills were not all expected to pass and become law, but there was a degree of bipartisan support here, which is rare in the United States on almost any issue at this point in time. And at this point, 2 of these bills have made it into the Senate and gotten a little bit of inertia. One is the ICO Act. And at its core, it's a ban on self-preferencing for a company's own products. This is a presumption in competition law in many places in the world. But in American law, there is no default presumption against giving your own products and services a preference in how you structure your business and your technical deals. So the question in the United States is, how far does this law as written go to things like Amazon Prime, or when you do a Google search, it pops up some related results at the top of that rather than just the organic results. Or when you go to Google Maps, it knows because you're a Google email customer that you have a reservation for this hotel at this day, et cetera, et cetera. So this level of integration is something very well baked into the internet that also gives rise to a lot of competition concerns. And that's, I think, what's at the top of a radar screen in the US. Now, we're in the middle of an economic downturn here and everywhere, and there's been a resurgence of interest as well in federal baseline privacy law. So, for a long time, tech observers in DC kind of wrote most of these bills off in Congress. But then Senate Majority Leader Schumer made strong signals of wanting to put the ICO bill in particular back up for a floor vote. There is a second bill, as I mentioned, the Open App Markets Act, which is more specifically geared toward app markets. And while I think that one is still also potentially viable, it's the ICO bill, the self-preferencing bill, that really has a big head of steam here. It's still, we're approaching the midterms in the US, always complicated politics here, hard to predict what's going to happen, other than that we, I think, can sort of assume at this point that the Digital Markets Act, which includes a much broader array of gatekeeper obligations than anything the US has any real viability for legislation, we're going to probably continue to look at that as setting the norm and standard. Still plenty of opportunity to do good work within that context, as sort of filling in gaps within the DMA and sort of being part of the collaborative process of developing the norms and standards that will come for that, which I'm sure we'll speak to later in this session.
Thank you so much. Stephen, floor is yours.
I'll try to be brief because I think it'll be the discussion and the Q&A from the audience that will probably be more interesting. And I'll try to address, Taylor, the questions you raised at the beginning. But the short answer, I think, is at EU level, we're rather in transition. I mean, there's a widespread feeling that the current system of ex post antitrust control wasn't really able to deal effectively, particularly with unilateral conduct and particularly with certain companies, for instance, in the pharma and the tech sectors, and also that, frankly, cases just took far too long. The EC, at the same time, I would say the Commission had become rather risk averse, partly because of losing a number of high profile cases. And as a result of that, decisions just became longer and more complex. I mean, when I started practicing EU law in 1983, for instance, it wasn't unusual to see decisions of 20 or 30 pages. And now they run into many hundreds of pages and annexes. And there is a problem that arose from that because traditionally, and I'm sure it's the same in pretty much all mature antitrust jurisdictions, the courts will give a great deal of deference to the regulators and to the authorities, particularly when it comes to matters of economic appreciation or assessment. But paradoxically, it seems to me at least, as the decisions became longer and more detailed, the courts actually seemed encouraged to delve into that detail and engage in far more second guessing of the authorities. Further problem, of course, was duration. Now, typical cases, unilateral conduct cases in the EU, particularly in the tech sector, will take something like 2 to 4 years. The courts then will take just as long again in reviewing them. So if we look at the Google shopping case, I think the court took between 3 and 4 years to review that decision, and that review, that result is itself now on appeal, so it's still unresolved. And this is a case that began with and I should declare an interest here. So I was involved in advising the company that filed the initial complaints in 2009, late 2009, early 2010. So we're 12 years on from that, and we still don't actually have an outcome yet. Another question, of course, was, have the remedies really been effective? It's been problematic, I think, with the Commission. They actually did have the power to break up companies. They've had that power for a while, but they've never used it. They had the power to adopt interim measures, which they've used really very sparingly. But even when they've taken decisions and adopted remedies, the companies seem quite adept at working their way around them. And if you look at the Google case, for instance, in the shopping case, there's really been no discernible impact on Google's market share in search, or even, one would say, particularly on its behavior. And the fines, of course, look huge. I mean, we've seen several fines now that have exceeded €1 billion on tech companies. Google's had a total of €8 billion in fines and 3 decisions. But to some extent, I think, this may be too glib to say it, but there's a feeling sometimes the companies really view that just as an acceptable cost of doing business. And the fines, of course, have never really approached the 10%, which in theory they could. So faced with all that, in EU, what we're doing now is we're moving to a system of ex-ante regulation, specifically in the tech sector. And we have, as Chris, I think, mentioned, or Taylor maybe, the Digital Markets Act, the DMA. And the plan under that is to regulate the largest gatekeepers, the largest platforms who have this, are seen as being gatekeepers to the internet. And we're going to do that. We're going to identify those platforms based on a number of metrics, and I can go into detail if people want, but I think you could look it up quite easily. But it'll be based on having a very high market cap, very high turnover, very large numbers of active users, and also, because it's EU legislation, being active in 3 member states. And the text has just been adopted, so it's been adopted at the political level. It could, I think, still be tweaked a little, but it's unlikely to change very much. And what will happen is that the Commission then will designate a number of companies as gatekeepers. Our estimate is that there will probably be 10 or a dozen companies. We've seen mentions of 15 or 20, but we don't see that there are that many companies in Europe who will meet those thresholds. So it's probably going to be closer to 10 or a dozen initially. And they'll then be made subject to a whole list of prohibitions, and these prohibitions will apply to all of the companies, although it's quite clear when you look at the prohibitions, they actually were drafted with individual companies in mind, and we've all played the game of going through the list and saying, well, this is the Amazon provision, this is the Apple provision, and so on. But there'll be classic prohibitions on behavior that's always been viewed as abusive, and Chris mentioned self-preferencing. You see in the list a restriction on self-promotion, promoting your own products, and, as you'd expect, restrictions on tying and bundling and other of those typical unilateral practices. And there will also be the ability, where companies don't abide by that, there's the power to levy fines of 10%. So again, the same sort of fining provisions as we have under classic antitrust. But designation is going to take some time. There's meant to be a dialogue with the companies. We believe in practice it's going to be quite hard for any company to challenge being designated, but Commission officials have said they expect to be engaged in litigation for some time, and the rules probably won't really bite on any of the companies until early 2024. And there are quite a number of open questions that are going to have to be resolved, and probably they will have to be resolved by litigation. For instance, it's not at all clear how much of a role there will be for the member states to take part in this enforcement activity. Certainly they want to. Germany has been particularly outspoken about its desire to be consulted. There's a question really about whether the national competition authorities, the NCAs, whether they can still take action under their own powers, and finally whether private citizens could take action for damages as well. So all those questions. The UK, I'll just touch very briefly on it, is taking a different approach. Please. Rather than have this list of prohibitions, they're going to deal individually with the companies and come up with codes of conduct that are tailored to them and are more flexible. So as you in Canada are looking at your own new approach, I would by all means look at the EU, but also look at the individual member states, France, Germany, certainly look at what the UK is doing. I think there's an opportunity for you to learn, particularly from our mistakes. Thank you.
Thanks so much. Orla.
Great. Thanks, Taylor, and thanks to CIGI for the invitation to participate in this conversation. So following on, I think, from what Stephen said nicely, I'm interested in the reforms in the UK and the EU from a slightly different perspective. So I'm a data protection or data privacy lawyer by training. That's my area of expertise. But I spent a few years in competition, and so I've been in practice in Brussels. I've been particularly interested in the intersection between competition and data protection. And this was a conversation that was launched in around 2014 in the EU by the European Data Protection Supervisor, working really off the hunch that competition and data protection frameworks should be interpreted and applied in a holistic way. And so the idea here might be that a competition issue or a lack of competition might have negative implications for data protection. But equally, the way in which data protection or data privacy frameworks could be applied or interpreted might also have competitive implications on a given market. So we have some very nice research by Michal Gal and co-authors showing how the way in which data privacy frameworks regulate data sharing might have market impacts. And so if we think of competition and data protection frameworks as mutually reinforcing, this begged the question about how this could be recognized in the existing legal framework. And if we couldn't do that, how we might introduce reforms that would recognize this kind of mutual reinforcement. So maybe just to give you a few examples before talking about the reforms themselves. One issue that has been raised a lot is the privileged access that companies, tech companies that operate across multiple markets, so kind of conglomerate tech companies, the privileged access they have to data. So if you think of a company like Google, it will have access to health information from a device like Fitbit, including sleep information. It will have access to information about your search queries through its search engine. It will have information about the content that you view through something like YouTube. And by combining all of these various data sets, it will be in a position to gain very privileged insights into your behavior, your interests, your potential consumer patterns in the future, etc. And that privileged insight as a result of its conglomerate market position is both a privacy issue, because you are able to get a bigger insight into the private life of more individuals than other commercial entities. But this could also be a competitive issue, because privileged access to those data sets could give a competitive advantage if you think of something like the training of AI models, for instance. And so you could see here how it would be important from a competition perspective for data privacy regulators to enforce the law correctly, and vice versa. Another kind of more obvious example might be the changes that Apple has recently introduced in its when it introduced the iOS 14 operating system, where it introduced an app transparency tracking framework. And this, essentially, you might have encountered it, requires users to grant their explicit consent to whether or not they want to be tracked by an application across third-party, across other usages on their phone. So it gives consent for third-party tracking via the app. And the claim here is that Apple's compliance with the data privacy framework in the EU is itself a breach of the antitrust rules, because it confers a competitive advantage on Apple by limiting the access of its competitors to data while privileging its own continued access to that data. So you can see here that there's kind of an unavoidable nexus, I would say now, between data protection and competition. But how is this being recognized by the legal framework? Well, first of all, we have changes, I think, in the EU in terms of how we define markets. So as Stephen has already mentioned, the DMA, the Digital Markets Act, moves away from a requirement to define markets in the traditional way and introduces the concept of gatekeepers, which is distinct, I would say, from the concept of market power, and recognizes that we might have a kind of strategic market status across several markets that is distinct from the way in which we would traditionally define markets in competition law. And again, you see that in the UK and in the German legislation that was introduced. Otherwise, we could think of the move towards incorporating data privacy considerations into the consumer welfare standard typically applied by competition authorities. So here, for instance, we have recognized in the EU that data privacy can form part of the overall quality of a service or of a product offered by an undertaking, and that a reduction in the level of data protection or data privacy offered to users is tantamount to a reduction in the quality of a given product on the market. So we've seen that recognized in Commission decisions. Obviously, that doesn't require legislative change to incorporate data privacy into the consumer welfare standard, but it might require change in focus in terms of guidelines. If, for instance, historically the focus has been on price, then changing to quality considerations might be something that needs to be signaled to market participants, for instance. But I think probably one of the big changes that this nexus requires is cooperation between data privacy regulators and competition regulators. And we see that in the UK, for example, through the Digital Regulators Cooperation Forum, the DRCF, which is a nascent cooperation forum involving the CMA and other competition regulators, as well as the UK's Information Commissioner's Office, the ICO. And there, at this stage, that's a kind of an informal cooperation framework, and we don't have anything equivalent at EU level. But I think at EU level, we will need to see that close cooperation, because again, if you look at this Digital Markets Act, a lot of the provisions it contains have explicit references to concepts found in EU data privacy legislation. So, for instance, the concept of consumer consent found in the Digital Markets Act is GDPR, or data privacy consent. And if I give you just one example of what I think is a particularly relevant provision, if you look at Article 5 of the DMA, what it prevents is cross-platform data sharing or data aggregation by these gatekeeper companies. So if we go back to that Google example I gave, Google wouldn't be able to combine the data that it gathers from search with the data that it aggregates from YouTube about the same individual, unless you have the explicit consent of that individual in compliance with data protection law. So we'll necessarily see kind of cooperation between the two regulators in that type of circumstance. So just kind of wrapping up and maybe thinking about some of the implications that this more holistic approach to applying legal frameworks in the digital environment might have for Canada. I think one omission I see in the EU framework is that we haven't yet tackled the question of digital mergers, which might be a proactive way to kind of head off some of the potential clashes that we see between data privacy and competition proceedings. So we might be able to discuss that. We have in the EU at least now recognised that we can't treat data protection and competition in a very kind of siloed way, even if they both start from very different foundations. You know, data privacy viewed in the EU as a fundamental right protected by the EU Charter, in contrast to competition, a kind of a pure economic policy. We do recognise that the two need to be applied in a harmonious manner. And then I think quite interestingly, because we're recognising this nexus, what we're seeing is a far greater range of stakeholders now involved in competition proceedings than was the case in the past. So if you look, for instance, at the Google Fitbit merger that I mentioned, or that at least indirectly earlier, Privacy International was granted standing on an amicus basis in order to assist the Commission to identify and to kind of parse some of the privacy implications that merger might have. And so I think in thinking about the role of these kind of broader stakeholders, it's useful to think, what standing are they given in competition proceedings? How can they be integrated in a seamless way into competition proceedings in the future? But I'll leave it there so we can have our panel discussion.
God, thank you so much, everybody. Look, there's a million different directions we could go here. And please, just a reminder to our audience members, you can put questions in the question box, and I will get to them as soon as they pop up. But I just want to start with something you all touched on briefly, and it seems to be almost a first principle of this discourse at the moment, which is the debate about whether and how we should broaden our notion and definitions of anti-competitive behavior. And in the proposed amendments to the Canadian Competition Act, this is sort of signaled via modifications to the abuse of dominance provisions that include, in what seems to me to be quite broad language, the inclusion of network effects that entrench dominant players, and Orla, to your point, the inclusion of protection of consumer privacy in these potential abuses of dominant positions. And is it right that this is really the first principle of this shift to extending competition policy into digital markets? And how do you all view that debate at the moment about how and whether we should be broadening our definition of anti-competitive behavior? Maybe Orla, do you want to just step on that first, just because it seems very much embedded in your argument that data privacy needs to be core to how we view anti-competitive behavior?
Yeah, I don't know if it would be my first principle for reform. I think there are other places you could start. But I think that given that so many digital services are offered for free at the point of access, where the fundamental in the exchange is personal data, then the conditions for that personal data processing become quite important to consider from a competitive perspective. And so in that sense, data protection is kind of immediately brought into the picture. And I think data protection can clearly be looked at as an element of the competitive exchange, as I said, as an element of consumer quality. Whether or not you actually need to explicitly state that in the law is a different thing, or whether or not the existing consumer welfare standard could be interpreted in a way to include data protection, I think is something that we could discuss. But I think that at least signals that the regulator is happy to incorporate data protection considerations into competitive assessments.
Yeah. Chris, this is, I mean, with Lena Khan's presence in the FTC now, this seems to have taken a forefront in the American debate. How would you characterize how that's played itself out publicly?
I would say Chairwoman Khan is one piece, but this is a very broad conversation, and you raise it in an interesting way, right? Market principles are still very central, and free market dynamics are very powerful for good reason in the American context, right? But market definitions are hard. What is YouTube? Is YouTube a video platform for commercial distribution of published content like Netflix? Is it a user-generated content media distribution platform? Is it a social network? It's just really hard to define markets in the current context, not just because of network effects, but because of interconnections of technologies and the ways that these things all intersect with each other. So when you start with an antitrust framework that says you have to first define a market and then identify monopoly behavior within that market, or in the case of mergers, like concentration within a market that reaches a certain point, it's incredibly difficult in the internet ecosystem. So little wonder that the instinct of policymakers is to create more affirmative, pro-competitive interventions and policies as a means of making the internet a sort of more traditional, not tradition for the internet, not talking about a long timetable here, but this sort of idea that the definition of the internet is very low cost market entry, very fluid market dynamics. These are valuable market principles that I think many people feel are not well served by the reactive antitrust paradigm that looks at markets in a more static way. So I think that we do see this transition towards a broader definition of competition interventions, like the definition of gatekeepers from that perspective. I wrote a paper many years back that I never actually finished and published, and I was looking at the principle of Schumpeterian creative destruction and sort of trying to make the argument that the interconnectedness of technology creates this opportunity for gatekeeping that allows for technical blocking of fluidity in the sense. Anyway, down a rabbit hole. But I think this is an old idea that is seeing new light in a lot of different places, that we need to be thinking about competition in this more robust and complex sense.
Thank you. Stephen, do you want to jump in on that?
Yeah, and very briefly, I was smiling actually because I was thinking back to the DoubleClick deal, and Pamela Jones-Harbour years ago was arguing, of course, that these data considerations should play a part in merger review, and she was very much in a minority at that time, and that has certainly changed. I mean, obviously in EU law, the concept of abuse has always been a pretty flexible one, and we've been able to bend it into all sorts of different shapes. And if you look at, again, in the Google shopping decision, there was more the concept now of talking about, well, is this behavior competition on the merits? You know, whatever that means. But it clearly then introduced the flexibility that Orla was talking about, that you can bring in all sorts of concepts. And you can see that with the DMA in one very simple way. There's a turf war going on that I don't think has been resolved yet, in that DG Competition, who, you know, handle antitrust, they want to be the enforcers of the DMA, but there's another DG that deals more with internal market issues that wants to be. And I haven't heard that has been resolved yet, but certainly where that lands in the end could certainly influence how the DMA is going to be interpreted and enforced in the future. And I think we could see a lot of these data considerations coming in.
Thank you. Another broad question I have, I suppose, also stems from Orla, one of your comments about the Digital Regulators Cooperation Forum. I moderated a conversation with a series of competition commissioners last year, and was kind of struck that it was the first time they had been in a joint event altogether, that cluster of 5 competition commissioners. And it seems to me in this space in particular, even more so maybe than other digital regulatory spaces, the need for some sort of alignment between jurisdictions is pretty high. Is that correct? Like, or is this a case where, I mean, I think, Chris, maybe you mentioned that it could be that the DMA just goes off on its own and has a real spillover effect in the American market. So how do you view the need for cooperation and even coordination of competition policy, and the idea that some markets are maybe just are big enough essentially that they can influence the behavior of companies in spillover markets? Chris, do you want to jump in on that? I mean, does the EU does the US need to move, or can they wait for the DMA to take effect, essentially?
I am fond of describing the Digital Services Act in particular as the next GDPR in terms of its impact on global norms. I think there's every reason to believe that the DMA could go down that same route, though I'm not as confident that the DMA will have the same global effect that I am the DSA, for a lot of reasons. First of all, that the DMA is a very strong law. It imposes quite a lot of obligations on platforms, and so I think they have incentive to fight it tooth and nail in court for many, many, many years. And the DSA, by virtue of being a little bit less viewed by the tech industry as a less hostile and a less severe intervention, I think the DSA will start to have immediate normative effect as soon as it becomes law. I do think that there has been a rise. I mean, I've seen, as have you, the rise in coordination among competition commissioners, still nowhere near the level of coordination that we have among data protection commissioners, right? There's an annual data protection commissioners conference and has been for years. And I think that's a wonderful thing. And I think it would be a very good outcome if we saw more coordination among commissioners. But again, you have this parallel track of the enforcers and the legislative processes. And while the legislation could throw any coordination or any plans that the commissioners may have entirely out the window, depending on how things go. And we've got another election coming up in the US in a couple of years, and we could have completely different paradigms here. So it's pretty chaotic.
Yeah. Stephen, do you have any perspective on that from the British case? I mean, it seems like some of these CMA investigations, for example, of mergers and acquisitions could have real effect on how these companies behave globally, even if they're just done in the UK. Is that correct?
I think they could. I think that's a really interesting point, because what I often had said to me is, well, these companies, they're so enormous that how does anyone ever regulate them, and doesn't it need international coordination? I actually think the reverse is true, because these companies are so big, but of course they want to have, if they can, a single and consistent business model across the globe. If they are regulated seriously in one important jurisdiction, and the UK obviously is itself quite a sizable part of the online market. So if either the UK or Germany or the EU really intervenes against these companies, then they may well find themselves, and we saw that with the GDPR. Obviously, GDPR introduced in the EU and has pretty much really set the standard for data protection across the EU. On coordination, I'd say very, very briefly, it does happen, though it comes and goes, and I think it depends on the personalities involved. So I would say Commissioner Vestager is much more in tune now with Khan and Kanter, and therefore we're going to see it. But the main reason we have it, I blame the American Bar Association, because, and of course Canadians have always been very active in that association, but they started getting all the regulators together for panels at the spring meeting in DC. And I think they forgot that having brought them together, these people were going to carry on talking.
That tends to happen. Orla, do you want to jump in?
Yeah, I think maybe 2 points just to note on that. So first of all, in the EU, we had a predecessor to the Digital Regulator Cooperation Forum, launched by the European Data Protection Supervisor. It was called the Digital Clearinghouse. And the idea was to get competition, data protection, consumer protection authorities together to discuss cases, but more in the abstract rather than kind of tangible cases. And that kind of fell by the wayside as a result of a lack of regulatory buy-in. And so it would be interesting to consider why that happened. I think there were some concerns about overlapping competences, potential turf wars between different regulators about different cases. And as I mentioned, we will see some clashes, I think, because of tensions between the different starting points of the regulatory framework. So again, if data protection is looking at this more from a fundamental rights perspective, usages of data, and yet a data processing practice might have privacy implications, but potentially enhance innovation. What do you do in that type of circumstances? Whose perspective prevails in essence? But then I think another interesting issue, which we might see between the digital markets unit that Stephen mentioned in the UK, run by the CMA, and the DMA, as enforced by the Commission, whatever unit or whatever directorate, is I think the regulatory perspective of both seems to be a bit different. So the CMA has said that it will operate the DMU in a kind of a co-regulatory spirit. So it will work with the companies that it is regulating to the extent possible, whereas the EU approach seems to be a lot more top-down. And I think that will lead to, in essence, a kind of a regulatory experiment as to which approach is more effective. Because at the moment in the EU, between data protection regulators who are forced to cooperate to apply the GDPR, what we're seeing is that behind the scenes, a lot of disparities are emerging between those who are kind of following a kind of a better regulatory framework where they're, again, adopting that co-regulatory approach, and others who simply want to throw the rule book at companies and to impose fines because they think that that is a more effective way to kind of rein in big tech. So you've probably seen some of those discussions about the discontent behind the scenes at the EDPB.
Yeah, and that's actually the last question on mine that I wanted to sort of push out, and we have a few coming in from the audience, so I'll get to those in a moment. But obviously, the space of competition policy has always been one of intense lobbying by corporate interests because it directly sort of fundamentally affects them. How would you all characterize the nature of that effort at the moment, both from the platform companies or the big tech companies that would be captured under the DMA, but also from more traditional large corporate interests here who have decades of experience navigating competition authorities and competition law? I'm thinking the banks and the telecoms, who both in Canada have a fair amount of weight, to say the least, in our public debate and our policymaking process. So how do you see these twin large interests reacting to this change in competition authority and power at the moment? Chris, do you want to maybe start with the US? Like, what has even just the lobbying been in pushback to the Klobuchar bill, for example, or to Lena Khan's presence on the FTC?
Yeah, well, there has obviously been a lot at Congress, and I'm not super in the weeds on the not in the halls of Congress, seeing people in the hallways or anything like that. But what I have seen has been less lobbying by interests outside of the technology industry and more lobbying from smaller companies who seek to benefit from opportunities that they view as being created by these rules, and then larger companies who will be affected by them. There's a ton of civil society engagement on these as well on both sides of this, picking up different pieces and raising concerns with the bills and raising opportunities that the bills present. So there is an enormous amount of activity. I don't see the banks or the telcos being super active here. And in part that may be because there are a lot of partnerships going on. I mean, the telcos want to get in on the internet edge gains and revenue streams as well, and they have to be worried about the politics of blowback on them, as they have spent years trying to define the broadband access market and the edge as fundamentally interlinked, right? They, in their engagements with net neutrality, have tried to say, but what about the edge? And so if they go and say, hey, the edge, lots of problems at the edge, that's like, oh, well, hey, don't forget about net neutrality, which we haven't put back in the law at the federal level yet. So I think there's a lot of sort of, and the banks, meanwhile, I think are probably more engaged and interested in conversations around cryptocurrency and general financial interests right now. So I haven't seen a lot of outside tech interests engaging in lobbying on this from my perspective.
Yeah, Stephen or Orla, any observations from the UK or the EU?
Yeah, I would say certainly some of the large platforms, I think, in relation to the DMA, woke up to the danger relatively late. And I think they also put a lot of their efforts into trying to stop something that frankly was unstoppable rather than shaping it.
Yeah.
What we're now seeing, though, interestingly, is some of them coming out and very publicly welcoming it and embracing it. And I think first of all, there's obviously a very genuine acceptance that the rules are changing and they will adapt with those changes. But also, I think the focus might now move to trying to broaden the scope of it so it captures more companies, because of course the very large platforms are very well resourced and very able to navigate these issues, and I think they may see that their smaller rivals actually will find it far more burdensome than they do. And on the sort of who's getting involved, I mean, Orla mentioned different stakeholders who came in on the Fitbit case, for instance. Well, one of the parties who came in, and it was all the first time they'd really got involved, I think, in a merger case, was the European consumer body, BEUC. Now, these digital markets, because they affect users directly in a way that many antitrust cases haven't. Many antitrust cases have been really B2B, but it's with the digital cases that you see the individual users much more directly impact. And so consumer bodies and civil, what we call civil society, have been far more engaged and have been seriously listened to. So I think that's a change from what we've seen traditionally in antitrust cases.
Yeah, Orla, do you want to comment on that? And actually, I have a question to follow a question from someone in the audience asking about that Google Fitbit merger and whether you think that data walls should have been a potential remedy under the Act.
Yeah, so maybe just to say about the lobbying and transparency point. I think Chris had mentioned earlier that the frightful five. Well, people have been talking, I think, in the EU context about the glut of regulatory initiatives that we've seen. So DSA and DMA we've been talking about. We also have the AI Act, the Data Act, Data Governance Act. And so, I think there's a disparity there in terms of the extent to which civil society can engage with those initiatives compared to, for instance, big tech. So when you have that kind of huge regulatory push, it's going to, I think, favor those that have the resources to engage in a very kind of structured way with the regulatory initiative. But yeah, on the Google Fitbit case, I had worked a little bit with Privacy International on that because they, as I said, they had also intervened. I think that shows that the way the remedy that the concession or the commitment that the Commission secured in order to clear that merger was a kind of a siloing of data for advertising purposes, and that I think shows some of the limitations, as other speakers have mentioned, about breaking digital markets down into the way we would traditionally define markets, because the issue here, of course, isn't simply about the use of data for advertising. It's about the use of data for any of Google's alternative services. And so the data silo was necessary, but completely insufficient in that sense. Because from a Fitbit user, I don't use a Fitbit, but if I were a Fitbit user, I wouldn't simply be concerned about my data being used for advertising. I would also be concerned, for instance, about Google's future movement into healthcare services, about how that data might be combined with my search data, about what implications that might have for future insurance premiums or other things. So we're as Stephen said, totally back into Pamela Jones Harbour territory here, and that was 2008, and still, 20 years on or 15 years on, we're having the same discussion.
Chris, there's a question for you here that I think is relevant to this conversation, and our host as well, which is a think tank in Canada that's very engaged in these policy debates at the moment. And it refers to all of the reports and the market research reports that you cited as having an influential effect on the policy shift that's happening here. And I'm wondering, it seems like those were all commissioned or either done by or commissioned by competition authorities themselves, as opposed to by independent outsiders. And how do you, is that important here, that we give that research power and to these authorities? And how do you see external stakeholders who are invested in this process engaging in that research process?
Yeah, well, there was a lot of variability among the three. So I worry a little bit about lumping them all together, because while they all did have government agencies involved in them, They all had different flavors to them, right? I think if you look at, especially in the US case, maybe less the Chicago School of Business report, which was a bit more academic in its origination, and more the House Judiciary Committee's October 2020 report that followed their 16 months of investigations. It throws off the timeline a little bit because 2019 was the UK and the EU. But if you looked at that House Judiciary report and the UK CMA report and the European Commission expert report, then you really do get the government says, we have a problem. We need to update our regulatory frameworks in this instance. We want to get other people, not staff, to put a lot. Well, in the House case, it was staff. So sorry. Again, these things are a little bit different. But I do think it's really important that it was government going out and not just passing a law, right? In another era or in another context, they might have just passed a law that said do something based on the best information we have. And I think it's great that they went out and canvassed opinions. I mean, I helped author a written comment on behalf of Mozilla, who I was working for at the time, for the European Commission's experts process. I got to make a submission. I made a submission similarly to the Competition and Markets Authority report, and was obviously called in and engaged with the House Judiciary process in many ways. So the ability to engage with these at this timetable, 2 years before a law starts to be introduced and starts to be developed, is incredibly good. At just making the law better than it otherwise would be. So love seeing it, love to see more of this kind of intentional inclusion of non-governmental stakeholders in answering these really, really complex questions. They have simple principles, but their implementation in laws is anything but, and it's great to see that open-mindedness.
Thank you. So we have time for one more question here from the audience, and it has to do with the commercial cloud. And I suppose where we're targeting our digital antitrust and competition policy attention at the moment, and are we missing something by not spending enough focus on the commercial cloud, and are there competition issues emerging there that should be on our radar? Who wants to take this one? Stephen, do you want to go first, and then maybe Orla?
I'm trying to remind myself where we left cloud in the DMA. I mean, it's touched on. Orla probably knows it better, but no, I'd struggle to give a clear answer to that. I know there was a lot of to and fro about it. There was a sense, and I can include myself in this, that a lot of people were talking about the cloud who didn't know what the cloud was. I actually got myself a book on to explain to myself what cloud is, and I'm still struggling to get through it. And my feeling was, listening to the debates, that the regulators were having the same problem.
Yeah. Chris, if you see, how does it something like this tech stack debate? This is something you've been very involved with, this debate for many years, over where the point of regulation is in this space.
I think that the shift towards articulating and defining a gatekeeper and looking at what constitutes a gatekeeper and how the actions and the operations and the policies and the implementation of technology at one level affects the operation, not just of horizontally placed competitors, but also downstream companies trying to innovate on top of the infrastructure. I think that gives us a little bit of visibility into this. I spoke 6 years ago now, I think, at a conference. It was a World Hosting Day conference for a bunch of cloud companies. And at the time, I praised them. I said, from a competition perspective, I see so much more sort of substitutability within the cloud infrastructure. And yes, there's still big players. There's still a disparity here, but I think it fits a little bit, from my perspective, it fits a little bit more classical economic principles of you achieve benefits from scale, but there are opportunities to differentiate yourself as a new entrant in the market. So I don't see it as a core for this conversation. However, the shift towards thinking about gatekeepers gives us the opportunity to apply the frameworks that we're developing today to pro-competitive opportunities to increase competition within the cloud should such arise down in the future.
Yeah, and maybe just to add very quickly, there is obviously the flexibility under the DMA to bring in other companies, even if they're below these thresholds, although that will be a longer process.
Wonderful. All right. Well, look, we're coming up on the close of the hour here. I just want to thank the three of you for taking the time to join us. I'm consistently struck in this, and one of the most exciting aspects of working in this policy space, whether it's competition policy or broader digital governance generally is the way countries are beginning to learn from each other. And so the more we speak across jurisdictions and between people working in different jurisdictions, the better directionally we're all going to be here. And so Canada being a little slow on this file means we have the benefit of learning from what others have done before, right and wrong. So thank you so much for joining us, and hope that we can continue this conversation. Just to people watching, the resources around this from the CIGI end are in the Zoom chat. And we are having one more event in this series of competition policy. The information about that is also in the Zoom chat. So thank you so much, everybody, and see you again soon.